Welcome to HR Talk, People Management's regular discussion about the topics making the news in the HR world. I'm Jill Evans, and I'm joined this week by Michael Bronstein, a partner at city law firm Salins. We're going to be talking about an issue which has bothered HR professionals for years, whether it's possible to make women on maternity leave redundant and keep within the law. Just recently there's been a case in the news involving the law firm Eversheds, which shows how easy it is for employers, even those with the best intentions, to fall foul of the regulations. But before we get on to that case, Michael, can we start by explaining what special treatment women on maternity leave are entitled to during the redundancy exercise?
Yes, it's probably a slight misnomer to say that women on maternity leave are entitled to special treatment. They have a number of rights. Firstly, as women, they're entitled to be treated no less favourably, not to be subject to less favourable treatment than a man would be in comparable circumstances. Secondly, there's special protection under the Equality Act to the extent that a woman mustn't be treated unfavourably because of anything to do with pregnancy, childbirth or maternity. The special treatment that was the focus of the Eversheds case was in fact a rather more limited provision in the legislation which derives from European law, which says that if a man were to complain of being discriminated against because he had been treated less favourably than a woman, no account should be taken if the woman had been given special treatment because of a reason to do with pregnancy or childbirth. So, as I say, in the Eversheds case, the special treatment is there to really prevent a man from being able to make a claim rather than to give a woman an additional entitlement to the other rights which I've mentioned. Right.
Can you explain a little more about the circumstances of the Eversheds case?
Sure. Essentially, and sadly, a redundancy exercise had to be undertaken within the department in Eversheds where Mr. de Bailin worked, and the redundancy pool comprised him and one other employee, Ms. Reinholz, a woman, who was on maternity leave at the time. Eversheds quite properly went about constructing selection criteria so as to be objective in determining which of those two, Mr. de Bailin or Ms. Reinholz, would be selected for redundancy. One of the criteria that they chose was the period of lockup, i.e. the period between which work is done for a client and the time when the client actually pays the firm for the work. The problem that arose was because the period chosen by Eversheds for measuring that criterion of lockup was a period when Ms. Reinholz was away on maternity leave. So Eversheds said that in order to make sure that she wasn't disadvantaged as a result of that, they had to give her, in their view, the maximum score for lockup. And the result of that was that she got exactly half a point more than Mr. de Bailin did, and as a result of that half a point, Mr. de Bailin was selected for redundancy. Eversheds said that they had to give Ms. Reinholz the maximum score to make absolutely sure that she wasn't disadvantaged as a result of having been away. And they said that the special treatment provision in the Equality Act that we talked about earlier, although it's quite limited, nonetheless really mandated them to accord her that treatment, and Mr. de Bailin couldn't make a claim for discrimination as a result. Right. So the argument in the case was really about the extent, how far that special treatment is allowed to go before a man can say, well, that's not fair, I am being treated less favourably because I am a man, and I've suffered a disadvantage myself as a result of that. And what the case went to the Employment Appeal Tribunal, and what the Employment Appeal Tribunal said was that special treatment for this purpose did not mean maximum advantage, and that adopting a very broad principle of European law, which is one of proportionality, what Eversheds should have done was to find a proportionate way of countering the disadvantage to Ms. Reinholz of having been absent on maternity leave during the period when lockup was being measured. And the EAT said that there were a number of ways in which that could have been done. One way would have been to have chosen a different period, being the period ending when she went off on maternity leave. So you're looking at a period when she was actually working, compare that with Mr. de Bailin's score in the same period, and that would have been a proportionate way of achieving the result of negating the disadvantage to Ms. Reinholz of having been on maternity leave. And the effect of that exercise would have been either for the scores to be equal or, in fact, for Mr. de Baelen to have got half a point more. The result of that would have been that Ms. Reinholz would have been selected for redundancy and Mr. de Baelen would have kept his job. I think a point for employers to note, however, is that quite often in these cases the sting is in the compensation tail, because it turned out, according to Eversheds, that even if Mr. de Baelen had kept his job, there would have been a further round of redundancies. There was a further round of redundancy within a short period afterwards, and therefore he would have lost his job in any event.
Gotcha. What are the lessons that employers can learn from this case, do you think?
I think lesson number one is that although women who are pregnant or on maternity leave do have a range of protections under the law, principally not to be treated unfavourably because of pregnancy or childbirth, and obviously specific rights to maternity leave and maternity pay and so on, and therefore they do have a special position within the law. Nonetheless, the idea that you can't make a woman on maternity leave redundant is wrong. If there is a redundancy situation, i.e. if the needs of the business for people to do work of the kind that that woman is employed to do has ceased or diminished, then potentially it's appropriate for the employer to make that woman redundant if that's the result of the normal redundancy process of finding objective criteria and going through a fair consultation process. The lesson, I think, for employers is that when constructing the criteria, on the one hand, they have to make sure that women on maternity leave are not disadvantaged. For example, by choosing a measure when she was away from work, or if that does happen, to make sure that an adjustment is made in a proportionate way so that the disadvantage is cancelled out.
So plenty for employers to think about there. Michael
Indeed.
Bronstein, thank you very much for joining us.
Pleasure.
And until next time, goodbye.